Lordship. 109 PM, attempt to murder Lordship.
Next week or date at December? 16 December.
May please, Your Lordship. I pray for listing of a criminal revision petition. On 5th of December, this court has allowed to list the matter for today, but the matter has not been come up. Kindly, madam, taken on Monday, Your Lordship.
No, revision petition after vacation.
No, Lordship, there is an urgency because trial court proceeding has been going on, Your Lordship. We have to pray for a stay in the entire proceeding. There is a gross irregularity of the entire impeachment judgment, Your Lordship.
What is the stage of the proceeding?
The stage of the proceeding, hearing matter is a hearing. It's a DV matter. It's going fixing for next week for hearing, Honor.
Hearing judgment?
Yes, for hearing. That is why I pray for this.
For judgment?
No, for hearing of the argument of the hearing entire matter, Your Honor.
Argument?
Yes. That is why I pray for this. For
Date at next week.
on
17 December.
I beg to mention for listing on AP Lordship, ideal Lordship, because the petitioner is a doctor and I was service notice under section 94 BNS to appear on 15 Lordship for a recording his statement. That's why I pray for listing on ideal Lordship.
What is the punishment?
Punishment 89, 69 Lordship.
What will be the punishment under section 69?
7 years.
16 December.
15 December is lost fixed for IO fixed for to appear before the IO Lordship. It will be Friday Lordship. Other IO direct to appear on 15/12 Lordship. That's why I pray for Friday Lordship 12.
Okay.
May it please, Your Lordship. Item number 19. Your Lordship has earlier rejected the bail application, but on the last occasion, there's an observation from the Supreme Court at this.
Just moment 15, I will have to go away somewhere in the afternoon. Just a moment, not on 15. Afternoon, I have to go somewhere. Go jabo na. Monday, koi diba de mo afternoon to. No. 30 before different. Yes.
Item number 19 may kindly be taken up on 22nd or 23rd January as per Your Lordship's convenience. Because one of the witness was to be examined on the last date. The witness did not turn up. His next date is fixed on 19th of December. So I pray, my lord, let that witness be examined. We'll produce that certified copy of the deposition of that witness.
Learned Senior Counsel Mr. B.D. Kaur has prayed for adjournment. List the matter on 22nd January. Khula ase na? Yes.
Obliged.
No, next week, not next week. 7 January.
May I please request, Lordship, item 11 of today's list, Lordship. On behalf of SC Vishwas, I am praying for short adjournment. He has not come to court today, Lordship.
Item number?
11. Lordship, kindly fix a short date.
Learned Counsel Miss
Debashree Chakraborty.
D. Chakraborty. For, on behalf of Learned Counsel Mr.
SC Vishwas.
SC Biswas has prayed for adjournment. List the matter on 6 January. Positively for hearing, as this is a long pending case.
Grateful, Lordship.
Recommended on criminal petition for listing Lordship.
No. In January.
Petition is very poor person and for
January.
any date in Lordship next week.
May I please, Your Lordship? Lordship, I beg to mention for listing of one IA criminal, Lordship, for correction of the order. Kindly matter may be listed on tomorrow, Lordship.
No, not tomorrow.
IA criminal, Lordship. Order has already been passed, Lordship, but
Bail.
Bail, Lordship, but there is a small error,
Alright.
Lordship. Tomorrow, Lordship. Obliged.
Lordship, I beg to mention listing of one criminal petition, Lordship. It was filed in month of April, 11th April, but till date, even not motion happened because so many 5 occasions left over matter.
Bail application, criminal petition.
Criminal petition, Lordship.
Or after vacation.
Lordship, kindly on 16th, Lordship.
No.
Because his personal liberty is restricted in.
You are this case is at which stage? Motion stage?
Motion stage, but in every date left over matter, last 4 days.
Didier Kunbata. motion. All this will matter, all these matters will come up with the motion stage. Because the circular has been, notice has been circulated.
Lordship.
Mm.
Highly obliged.
Second,
Mm.
this may come on 1912, my lord, along with FB number. Item number 7.
Okay.
FB number 2807 of 2025.
List this matter on
1912,
1912 along with AB number
2807 of
2807 oblique 2025.
May I please lordship, I beg to mention item 23, my lord.
Mm.
I think CD is not there. So my lord, after vacation, my lord, January, my lord.
CDS call for is not received, issue
But-
reminder, list the matter.
Mon-
On vacation officer data DDA. You are on interim bail?
Yes, my lord.
Our officer DDA.
21st of January.
And there is an order also,
Shall remain in force till the next date.
and there is an also order, my lord, to for listing the matter appropriate bench, because my lord, similar matter was disposed of by the Honorable Justice
That will
Well-
prevail.
published.
May I am praying for listing of a petition for withdrawal, my lord, on Monday, my lord. Withdrawal, my lord.
May I please, lordship?
On Monday, not on Monday. On Tuesday.
May I please, lordship? I beg to mention item 20, lordship. Kindly pass over for the day, lordship, after vacation. Item 20.
Learned counsel,
S.A.
your name?
Mandal. S.A. Mandal.
CD also not received, madam.
okay.
No entry.
Learned counsel, Mr. S.A. Mondal,
S.A.
on
Mondal.
behalf of learned counsel, Mr.
A.R. Karim.
AAR Korim has prayed for adjournment. CDS call for is not received. Issue reminder, list the matter after vacation. Vacation or data.
Perfect.
I'm praying for listing and lordship. Daily hearing column, lordship. It was listed on 1/12/2025 lordship. Now it is not been listed, so I give
Bail hearing.
Wait here.
জানিব চাগে punishment. What is the period of imprisonment?
More than 7 years.
Okay, on Friday.
Lordship, I am praying for listing of my bail application, Lordship. And it's NDPS here, Lordship.
Mm.
Bail application number is 3705, Lordship. It's on, maybe listed on 12/12, Lordship. That is on Friday.
No, not on Friday.
16th.
AB,
Lordship, it's a BA, Lordship. I want to withdraw the same, Lordship. It was not listed, so that's why I'm praying.
you want to withdraw?
Yes, yes.
All right,
yes,
on
Lord.
Friday then.
Give, and
I recommend item number 22.
Hmm.
Yeah, John for the day.
Learned counsel, Miss N.A. Begum
Anyway,
has prayed for adjournment.
interim is there.
Huh?
Interim is there.
List the matter on.
22nd January.
You have the CD?
Scandal copy.
Oh, scan copy.
May it please your lordship.
Hmm.
I beg to mention for a listing of a criminal appeal for hearing, lordship. If possible next week, because the father of
Next
the
week is only for motion. Criminal petition.
criminal appeal, lordship,
Criminal appeal January. He's behind bars
behind bars, lordship.
for hearing. January. No, no, আগত দি দিয়ে. Bail of behind bars আছে. 8 January.
In the outside. We have final objection. Our objection will be called. 16.
May I please, your lordship?
Hmm.
Lordship, I'm appearing on behalf of Sumita Gohai Borwa.
Mm.
Lordship, as my senior has to leave for
Okay.
outstation court proceeding, so the matter may be adjourned for today.
Which item number?
8. Lordship, can it be fixed on next Wednesday?
Your name?
C. Saikia.
Learned counsel, Miss C. Sirkia, has prayed for adjournment. List the matter when do you want?
Next Wednesday, 17.
Okay.
Highly office.
Item number 1, motion.
Well, can it be taken up after some time, madam?
Item 2.
Here in this case, my lord, in terms of earlier order, my lord, the petition had appeared before the IO, my lord. Thereafter, my lord, the charge sheet had been filed. And after charge sheet, my lord, the honorable court was pleased to direct the petitioner to approach the judicial court, my lord. The judicial court, my lord, there, my lord, the on the youngest council, my lord, here, where the statement, my lord, wrongly, my lord.
Charge sheet has been submitted.
Charge sheet has been submitted.
Have you 436?
Yes.
Have you applied for bail in the lower court?
Yes, yes.
District judge?
Yes, yes. It
Has
was-
been
yes,
rejected.
yes. My lord, there, my lord, what happened, my lord?
Yeah, no, we'll call for the CD.
This year.
Charge sheet has been submitted. no?
Yes, yes.
Yeah. Call for the scan copies of the trial court records, list the matter after vacation, huh?
My lord, petitioner before he lost with a government employee, my lord. And his statement was recorded
No,
earlier,
no,
my lord.
he is not arrested. We'll have to take it after vacation. Now we will take up only those who are behind bars.
My lord,
5th January. No, no, no. no.
I am petitioning government servant, my lord. His statement was recorded, my lord, earlier, my lord.
But charge sheet has been
Only,
submitted.
my lord, intent petition, my lord.
And then you see district judges, why couldn't you convince the district judge?
My lord,
District
because
judge has rejected the bail.
there is a wrong statement made by the advocate, my lord, there. Only for that, my lord.
No, no,
petitioner
please do
cannot
not insist in this manner. From first week of January. 5th.
My lord. Obliged.
Hmm.
Okay, call for trial court.
My lord, may I please?
That case, no, for hearing, call for the scan copies of the trial court records. I think I have dictated.
5-1.
Hmm.
May I please, lordships? In this case, my lord, the one, my lord, motor vehicle accident matter, my lord, that is in the year of 2022, my lord. My lord, in the year of 2022, my lord, on 25th of January, my lord, motor vehicle accident took place, my lord. And as a result of which, my lord, the husband of the respondent number 2, my lord, was
He
died.
died.
Yes, my lord.
Hmm.
And thereafter, my lord, at the same moment, immediately after registering the case, my lord, the matter has been amicably settled in between the parties, my lord. And thereafter, they have also approached before the, my lord, officer inserts to.
No, they cannot. Okay, I understand. Yes.
But my lord,
Okay, you want the proceedings to be stayed,
yes,
amicably settled.
yes, my lord.
Any documents regarding?
My lord, a settlement, my lord, that was in the Dibrugarh, my lord, at their hands, my lord. Yeah, at
No,
this stage, my
no,
lord, notice may be issued, my
We'll
lord.
issue only notice though. We won't
Notice may be
stay.
issued, my lord, and short date may there. Otherwise, my lord, on next 20, my lord,
Learned Counsel, Mr.
January 20, case has been fixed, my lord, in
Okay,
trial
before
court.
that will fix. Learned Counsel, Mr. S. Ahmed
Yes, ma'am.
is present for the petitioner who shall issue notice to the respondent. Issue notice to the respondents returnable on date data DDO.
20th of January.
Call for the scan copies of the trial court records.
Obliged. Obliged, my lord. Much
Yeah,
obliged.
I'll record your presence or I'll leave it as notice.
Man.
At notice.
Present.
Presence, okay. Learned additional PP, Mr. B. Soma is present for the, you have made the other side a party.
Other side,
Corporate side.
respondent number 2.
Okay,
Informal.
has accepted notice on behalf of respondent number 1 and thus no formal notice is required to be issued.
I will take a step, my lord.
Yes.
Obliged, my lord.
Extra copies to be
Fixed
funded.
on 9 January. Obliged, my lord. Much obliged.
My lord, in this case, lordship, the trial court lordship has allowed the prosecution to submit the additional document lordship after commencing the trial. On the last day lordship, they were supposed to submit lordship any citation if they found lordship.
After some time. After some. Yes, meeting.
After some time then.
I can buy.
May I please, Lord?
Mm.
This application lordship for quashing of the charge sheet lordship. Allegation against me that lordship petition has taken an amount of rupees 15 lakhs from the private respondent number 2. An entire amount was already paid by way of agreement lordship, amicably settled. So I pray for stay at this stage lordship.
Where is the agreement?
Page 26 lordship. Start from page 25. This is an agreement initially lordship, 6 lakhs, 8,50,000 has been paid. And then thereafter lordship, another agreement was finally executed lordship. It was on page 32 lordship. Page 32, a relevant portion, page 33, Lordship, start from para 3, Lordship. The first party shall not interfere in any dispute between the Sri Suraj Bhan Singh Bhandari and also no objection for granting bail by Honorable Guwahati High Court against him. And second party has cleared all the liabilities and has paid the total amount of rupees 15 lakhs and shall not be liable to pay any amount to the first party as aforesaid. They have
Yes, yes. Can state, I think.
15 March 2025.
This says notice may be issued for it. Let them come and say that.
It is a complete civil nature dispute, Lordship, and there are so many Supreme Court judgment that police cannot act as a recovery agent, Lordship. I will place a judgment of the Supreme Court, Lordship.
Not doing their recovery agent manner, doing their appeal, but they
It is a
have filed charge sheet submitted.
the charge sheet, there is no,
Recovery agent.
my submission is that, Lordship, there is no performance material because it is complete like civil dispute, Lordship, between complainant and the accused, Lordship. And now the amicably settled the matter also, he has received the money also, Lordship. And in the bail application in High Court, Lordship, the Lordship will find a copy of the submission of the advocate of the
That fire was lost on in the month of February. Yeah. In the month of February, the fire.
Lordship and 14 February, Lordship,
So this was executed after the fire.
after the FIR, Lordship.
Can we state, I think? Your name?
US Borgohain, Lordship.
Third learner comes from Mr. US Borgohain for the petitioner. So and so, who has filed this application under section 528 of the BNWS 2023 with prayer for quashing the proceeding of PRC case number 158 of 2025 arising out of so and so PS case under so and so sections.
And pending in the Court of Judicial Magistrate First Class Bishop Saili.
Heard Mr. B. Somar, learned additional PP Assam, who stopped the learned additional PP has resisted the prayer for interim stay of the proceeding of the aforementioned case, full stop. The learned additional PP has accepted notice on behalf of respondent number 1 and there's no further notice is required to be issued. Extra copies to be furnished, full stop. It is submitted on behalf of the petitioner that an allegation has been raised by the respondent number 2 that the petitioner has cheated him of an amount of rupees 15 lakhs.
15 lakhs.
Full stop. The annexure page 32, no?
32, Lordship.
It is submitted that the annexure 6 of the petition is an agreement executed between the respondent number 2. This is not agreement, no?
Agreement, Lordship. Page 34 is the name of the party, Bharat Hazarika, who is the informant, and Binod Singh, who is the representative of the.
Okay. Between the respondent number 2 and, but who is Suraj Bhan Singh?
Suraj Bhan Singh is a petitioner and Binod Singh is the representative of Suraj Bhan Singh. On behalf of Suraj Bhan Singh, Binod Singh paid entire amount also.
Please read the agreement. Entire agreement.
The agreement is made on the 15 March of 2025, Bharat Hazarika and Binod Singh. Whereas the first party and the second party comes to an agreement under the following terms and conditions in front of the below signed witnesses. And before that, another agreement also executed, Lordship, para 6, para.
Where is it mentioned that this?
They are the representative for it.
And I will show it, Lordship. In para 5, Lordship, there is para 5, Lordship, page 33. The white agreement dated serial number so and so, which is also a part of agreement. That agreement, Lordship, will find in page 25, Lordship. When the 8,50,000 was initially paid, Lordship. Here the second party, Lordship, Binod Singh, the second party, where is the Suraj Bhan Singh Bhandari, son of so and so. His name is, entire thing is written, Lordship.
Please read it.
The Binod Singh so and so is the second party. Where is the Suraj Bhan Singh Bhandari, son of so and so, resident of so and so, is present second party, and Suraj Bhan Singh Bhandari has taken a loan amount of 15 lakhs only to the first party, and that is Bharat Hazarika on dated so and so, and promises to return the aforesaid loan amount within 1 month from the date of the receiving the aforesaid loan amount. And Suraj Bhan Singh Bhandari has already paid an amount 8,50,000. Initially, 8,50,000 was paid when he was arrested, Lordship. And thereafter, around 53 March, Lordship, entire amount was paid, Lordship. And there is at the time of granting the bail, Lordship,
Yeah,
there
please
is-
sit down. Please sit down. I'll go through the documents.
Right,
Please sit
sir.
down. Where is the East-End number, agreement serial number 3349?
3349, Lordship, will find in page 24,
Where?
where the photo has been annexed.
There's no photo here.
Yes, Lordship, in page number 24, Lordship.
Yes, page number 24.
24 on this part, Lordship.
Okay. Okay, 3349, okay. And the East-End number? Okay, I got it. Where is the FIR?
FIR,
Okay,
Second, sir.
page 26, yes.
Second question,
Mm.
the second party sale found to return the aforesaid amount of rupees 6,50,000 only to the first party on or before first day of March 2025.
that was paid on 15.
Yes, return. Mhm.
Lordship, would find very much clear on page 37, Lordship.
Mm.
Where is the bail order, Lordship? Para 5, Lordship. The Mr. Pathak Learned Counsel for the informant. Informant was appeared at the time of bail application, Lordship.
No, no, no,
Suppose
it's okay, it's okay. Where is the FIR?
that FIR is Lordship page,
It is the submission of the advocate.
yes, Lordship.
Mm.
Page 15, Lordship.
Mm. Submission of advocate won't work. Page 15.
Page 15, Lordship.
Mm.
Page 16 is a relevant point, Lordship.
Mm.
Start from 8 line, Lordship. There are 15 lakhs to recover his lost money, and then the complaint give him 15 lakhs within 3 days. and proposed the forthcoming the sale, but the said Surajban Singh Bhandari not return 15 lakhs.
No, please don't read in a slipshod manner. Please read serially from the beginning.
From the beginning.
Mm.
With due respect, I beg to state that I am a hotel businessman of Sotia. About 3 months ago, two young men from outside the state come to my hotel, Gungun. They introduced themselves a Kapadia Group company representative and told that land was needed for setting up a factory of the said company in the Sotia area. The said youth are Surajban Singh Bhandari and Lucky Singh came to Gangar Hotel of the informant several times. Accordingly, the complainant was ready to hand over 25 acres of land which was in the name of his family and inspected the land after making the royal agreement of rupees 6 crore with Surajban Singh Bhandari. Thereafter, Surajban Singh Bhandari introduced the complaint with one person, namely Rahul Kapadia, who introduced themselves as the owner of Kapadia Group of Company at two luxury hotels in Guwahati. At the hotel, a Pacha game was started between Rahul Kandiv and Surajban Singh Bhandari, and the said game, once a time, Surajban Singh Bhandari lost about 90 lakhs and he asked the informant to lend him 15 lakhs to recover his lost money. And then the complaint gave him 15 lakhs within 3 days for the purpose of forthcoming land sale, but the said Surajban Singh Bhandari not returned up the 15 lakhs and he stopped the communication with the informant over telephone. And now, most important, Lordship, this affair was lost. What is the pair before the IO? Therefore, Your Honor may kindly.
But why is Vinod Singh giving the money? Suraj Singh Bhandari, the allegation is against Suraj Singh
Suraj Singh Bhandari. And money was paid on behalf of Suraj Singh Bhandari by Vinod Singh, Lordship.
Why?
Why means because he was arrested and he was disturbed by because he
How
was.
is he related? Vinod Singh?
Vinod Singh is a business friend, Lordship. And last prayer, Lordship. Therefore, Your Honor may kindly investigate the matter and take necessary action against Surajban Singh Bhandari. And I hope that Your Honor may kindly help to recover my money.
Let's go to the agreement again. Vinod Singh. Okay.
Then Lordship to come and then page, start from agreement 24, Lordship, page 24. 11% 25, Lordship. Here is the Bharat Hazarika, who is the informant of this case, Lordship. And Vinod Singh is the second party, and he was represented, Vinod Singh represents to Surajban Singh Bhandari. And first agreement, Lordship, 8,50,000 was paid, and thereafter in page 32, Lordship, another rest of amount 6,50,000 was paid and amicably settled the matter. And with para 6 of the page 33.
Okay. All right. Okay, call ke kusluma. Aru kohasun. And Vinod Singh, huh?
Representative of the.
No, respondent number 2 and Vinod Singh. Vinod Singh. Annexure kiman kosilo? 6. To stop annexure 6, it is also annexure 6 depicts likhi diya. Annexure para to stop likhi diya. Para paragraph 5 of annexure 6 depicts that an agreement was also executed between Suraj Singh. Oh, no, Vinod Singh. The agreement was earlier. No, that was between Suraj Singh only. Or Vinod Singh. Both the agreement. Vinod Singh and the respondent number 2 as his brother. Suraj Singh is brother.
Suraj Singh is my
Whereas
instituted friend.
Surajban Singh Bhandari, son of Meherban Singh Bhandari, comma, is the brother of Vinod Singh. Is present. Second party, Suraj Singh Bhandari, I think brother.
Maybe, Lordship.
Comma, brother of Vinod Singh. Earlier executed an agreement to pay the entire borrowed amount of rupees 15 lakhs to the lender, respondent number 2, full stop. Annexure 4 is the agreement with serial number 3349 and E-STEM or what is it called? E-STEM number 00273 79118 full stop. After Binod, who was arrested? Binod Singh.
Suraj Bhat Singh arrested.
After Suraj Ban Singh was arrested, Binod Singh had agreed to repay. Binod Singh initially paid 8,50,000 out of rupees 15 lakh, and the remaining amount has finally and the remaining amount was to be paid on before 1 March 2025. Most of the remaining amount has been paid on 15 March 2025. Full stop. It appears that the proceedings of the aforementioned PRC case number can be stayed. List the matter on. Huh? Yes. Issue notice to respondent number 2. Meanwhile, the proceedings of PRC case proceeding. PRC case number so and so arising out of so and so case is stayed till the next date of listing.
Obliged.
Charge sheet has been submitted. Call for the scan copies of the trial court records.
Obliged.
Lordship, I'm praying for time being.
Time being.
Time being.
Passport time being, other code. Passport time being.
All right.
Item 10.
May I please, Your Lordship? Your Lordship, filed this application for quashing of the charge sheet and FIR, Your Lordship. Your Lordship, what happened in this case, after filing of the FIR, I came before your the dishonorable courts with an application for passing of the proceeding, Your Lordship. And page 46, Your Lordship.
FIR.
Page 46.
Charge sheet.
Order was passed by the honorable courts, Your Lordship, giving us, Your Lordships, the order of the honorable court, page 46, particularly post for 47, Your Lordship, last para. Since the charge sheet has been filed and learned trial court is yet to consider the charge, this court is not inclined to interfere with the state. Accordingly, petitioner disposes with the liberty of the petitioner to ventilate his grievance before the learned trial court at the time of hearing of the charges. Let the trial court so and so. You know, this is the observations. And accordingly, you also at the time of hearing of the charge, page 49, Your Lordship. Charge was framed. And charge was framed under section 420 and 376, Your Lordships. Aggrieved by this, Your Honor, I came before Your Honor. Your Lordship, Your Lordships. FIR may be taken into considerations. FIR is at page 26.
See, this is rape case. We'll have to issue notice.
No, Your Lordship.
No.
Issue may be issue of the 376, whether it is attractive. 420, okay. It may be considered.
We'll have to issue
Because
notice.
it is a consensual.
We'll need the scan copies of the trial.
The state, Your Lordship, the proceeding is.
The payment was made from 18 to 25, Your Lordship. Prior to that, Your Lordship, 11 lakh, 9 lakh is still pending, Your Lordship. Please say, Your Lordship.
11 lakh.
Yes.
Your Lordship, is the last order. I was, it was the order was stayed subject to payment of 10,000 cost and 10,000 monthly, my lord. That I'm paying, my lord. If the matter is settled otherwise, my lord, because there's a child. Your Lordship may fix the date.
Learned Counsel Mr. R. Day is present for the petitioner, and Learned Counsel Ms. N. S. Nazni is present for the respondent. Full stop. The Learned Counsel for the petitioner has submitted that the petitioner is willing to settle this dispute mutually. Whose of the Learned Counsel for the respondent has submitted for time to obtain instructions from the respondent if there is any element of settlement. List this matter on. We'll call for records.
The Lordship,
Call for the, this is disposed of case, no?
disposed of case.
Call for the trial sheet records. List the matter on 9 January. Assign the record 9, no?
9.
Item 17, 16.
Made to the lordship. Lordship, in this matter, we have challenged an order passed by the learned court below in criminal revision petition. The matter pertains to a proceeding under section 145, 146 CRPC.
Are you ready with the argument?
Yes.
Okay, you can start the argument.
Now, this petitioner, your lordship, he has purchased a plot of land from the cousin brothers and uncle of the respondent number 2 by way of 2 registered sale deeds. One dated 7th of March 2003 and another dated 26/4/2007.
Sale deed one dated
27/3/2003, 7th of March 2003,
7/3
2003,
and the other
26/4/2007. So
Okay.
after purchase of this land, your lordship, he has given the boundary wall construction, the matter is in his possession. Now what happened in 2009, your lordship, this respondent number 2, he has filed a petition before the learned ADM court for initiating a proceeding under section 145, 146 CRPC.
Petitioner number 2.
Respondent number 2.
Respondent number 2.
In the year 2009, your lordship, saying that he has right title and interest over the strip land and that I am disturbing his position. There is a likelihood of breach of peace for which a proceeding under section 1645 is required to be initiated, and he also prays for a injunction under section 146 attachment. Ex parte interim status quo, this injunction was granted by the learned court below. Thereafter, your lordship, the proceeding continued. At that time, an inquiry was, the ADM asked the circle officer to conduct an inquiry and submit a report. Accordingly, your lordship, the circle officer submitted a report on 27/1/2011, which is at Annexure 2, page number 25 of this petition.
Annexure
2, page 25 of the criminal petition. Now,
page 25.
25. In this inquiry report, the circle officer has conducted the inquiry. He has clearly said, may I read your lordship? In continuation of this office letter number so-and-so dated so-and-so, I have the honor to inform you that self along with LR staff visited physically to the spot at Moja Tarapur Part 6, Telegram PS Silchar District, Kachar. The land in dispute falls under Patta number 15, Dag number 65 of second arrest. I visited the disputed land and found a Kacha dwelling house on the said land, which is constructed by second party Khalikuddin Chaudhary, that is the petitioner here. The said land is bound by bricks boundary wall. The second party purchased the said land through registered deeds wide number so-and-so, 7th and deed number so-and-so dated 2007. And further moved the wife of second party Hamida Khanam Chaudhary also purchased the land, the said Patta, and the whole land total measuring 10 katas within the said boundary. The second party has been possessing the said land having dwelling Kacha house.
Okay, yes. There you are in possession.
I am in possession and I have purchased it. It is the not report of a police, your lordship. It is the report of the circle officer who physically visited and submitted the report, your lordship. So when this matter came that I have purchased the land by way of sale deeds and he knew it, then he moved a petition saying that he is ready to give back the amount of sale transaction and the land should be given to him. He moved a petition before the learned court below, which is at page number 26, Annexure 3. He admitted that yes, sale deed has been done. Okay, I will give back the sale transaction amount. Please, the land may be returned back to him. That was an application he has made. Lordship will kindly see.
Respondent number 2.
2.
Okay.
So that application was not considered because it is not a title suit that is being decided by the learned court below. But he has said that I will give back the transaction amount. The plot may be given back to me. Now, your lordship, ultimately, evidence were led. I have submitted 3 evidences: PW1, PW2, PW3, and he has also led 3 evidences: DW1, DW2, DW3. I cross-examined the witnesses adduced by him. He was given repeated opportunities to cross-examine my witnesses, but he did not cross-examine. And ultimately, by way of an order way back in 2023, Your Lordship, more specifically, order dated 16/8/2023, his cross-examination was closed because he was given sufficient opportunities, but he was not cross-examining. I have cross-examined his witnesses, but he did not cross-examine my witnesses. He was given sufficient opportunities, he did not cross-examine, and by an order dated 16/8/2023, learned ADM closed the cross-examination of DWs. Now, Your Lordship, during the pending
When cross-examination was closed?
16/8/2023.
Okay.
Now, during the pendency of this proceeding, Your Lordship, he also filed a title suit claiming right title and possession over the suit land. There also, Your Lordship, after filing of the title suit, I filed my written statement, but thereafter he did not appear, Your Lordship. And ultimately the suit was dismissed, title suit number 189/2014. During the pendency of this proceeding, this title suit was filed, Your Lordship, and it was dismissed by way of an order dated 9/9/2016. No appeal has been preferred against the title suit that has been dismissed, Your Lordship.
You have appeared in the title suit.
I have appeared, I filed my written statement, thereafter he did not appear, Your Lordship. Repeated opportunities was given, ultimately the title suit was dismissed, Your Lordship. Thereafter, he kept on not going to the court of ADM. The matter was pending, Your Lordship. Several opportunities was given to him. In the meantime, he filed an application saying that when the learned ADM at that time was ready to give the verdict, he filed an application saying that this ADM is not good, the matter should go to a different ADM. He has some doubt. Accordingly, Your Lordship, the case was transferred to another ADM also. Another additional district magistrate, Your Lordship. Thereafter, he filed a petition praying for impleadment of some parties. But the same impleadment petition was also dismissed, Your Lordship.
Okay.
Ultimately, he was not contesting that case properly. On 9/1/2025, a fresh police report was called by the ADM. The ADM called for a fresh police report to decide the matter on 9/1/2025. The police report was submitted, which is at Annexure 6, page 35.
Which one?
Police report on 9/1/2025, Annexure 6, page 35.
Again, one police report was called
Because the Lana ADM wanted to dispose of the matter, it is unnecessary being pending.
by the new ADM.
New ADM.
Okay.
This report also I have annexed. This report also establishes that I am in possession of the land and there is no breach of.
Where is the report?
At page 35, Your Lordship.
Okay. Page 35, yes.
Page 35, Annexure 6.
Hmm.
And in between, Your Lordship, the land has been mutated in my name also during the, after the title suit was dismissed, Your Lordship. Particularly title suit, when title suit is dismissed.
So land has been?
Mutated in my land, I have annexed at page 34. Mutation has been done in favor of the petitioner and his wife.
Okay.
And thereafter, Your Lordship, the ADM has passed a detailed order on 28/3/2025, saying that on the basis of the police report, also the basis of the circle officer's report, I am in possession of the land. And there is no chance of any breach of peace. For last 2009, the case is pending. There is no breach of peace.
So why are you here now?
No, I am here because by way of this order, the 145/146 processing was dropped and possession was declared to be in my possession. Against that, Your Lordship, he preferred an appeal before the learned session judge, which is criminal revision number 32 of 2025. The order of ADM, Lordship, will find at page 37. ADM order dated 28/3/2025.
That proceeding, when the proceeding was dropped, you
and
were given possession.
yes, I'm in possession. That report has also come. 28/3/2025.
Order dated
28/3/2025.
28/3.
3/2025.
Okay. Then they have preferred an appeal before the district
Against
judge.
this order, they have preferred an appeal before the learned session judge.
Okay.
It is criminal revision number 32 of 2025. and by way of the impugned order, your lordship, the learned session judge again remanded back the matter to the ADM for a fresh adjudication. After 2009 to 2025, a matter of only 145, 146 proceeding came to an end, your lordship. Without any application of mind, the matter was again remanded back, saying that you decide the matter afresh, your lordship. And that order is dated
Criminal revision petition?
number 32 of 2025. And that impugned order is dated 8/7/2025. Against which
Remanded back for fresh.
adjudication.
Where is the problem then? You are the owner.
I am the owner, but if 145, 146 proceeding does not lie, your lordship. Once title suit is being decided, your lordship. What is the purpose of 145, 146? That there is a possibility
Title
of.
suit was dismissed because he didn't appear.
Yes, once title suit is dismissed, then he has forfeited his right, your lordship. Whether he has title or not, that has to be decided by you of a title suit. He does not contest the title suit, but he is contesting.
This is not asking to decide the title.
No. Once title is decided in my favor, your lordship, then I am in possession of the land also. Why the matter should again be remanded back, your lordship? Whether there is any illegality or impropriety conducted by the learned ADM, your lordship. And there are settled.
So you are agreed by this order?
I am agreed by this order.
And order dated?
8/7/2025.
Page?
It starts from page 48.
So according to you, title was already decided.
Yes, once titles, the best remedy for declaration of a right title is it is the title suit, your lordship. He has also filed a title suit, your lordship. The title suit was also dismissed. He has never challenged that, your lordship. Now 145, 146, whether the title can be decided, your lordship.
No, he is not asking you to decide the title.
No, that is what he is saying, that he has title, he has right title and possession, and therefore he is the owner of the land, your lordship. Therefore, he is seeking, if he has not right title and interest, why he should disturb my possession, your lordship? And this is a settled position, lordship, by way of a numerous judgment of the Honorable Supreme Court, that once civil suit has decided a matter, your lordship, 145, 146 proceeding does not.
Give me the.
Civil suit has not, civil court has not decided.
It decided if he does not go, suppose I have filed a case, I did not come and I did not contest the case, it dismissed.
Give me the judgment. Only one judgment, huh? Latest.
Only to prolong the matter, your lordship, to disturb my possession, he has filed this 145, 146 proceeding. The best course and remedy for a title is, lordship, it is the title suit. It is 1985, 1 SCC 427, your lordship.
Okay. 1985, 1 SCCF.
425. I will read the second paragraph, your lordship. This is short judgment, your lordship.
Okay.
Challenge in this application is to the order of the Allahabad High Court refusing to interfere in its revisional jurisdiction against an order directing initiation of proceeding under section 145 CRPC and attachment of the property at the instance of respondent number 225. Indisputably, in respect of the very property, there was a suit for possession and injunction being titled suit number so and so, filed in the court of civil judge at Balia, wherein the question of title was gone into, and by judgment dated so and so, the said suit was dismissed. The appellant was the defendant in the said suit. According to the appellant, close relations of the respondent 225 were the plaintiffs, and we gather from the counter affidavit filed in this court that an appeal has been carried from the decree of the civil judge, and the same is still pending disposal before the appellate court. The assertion made in the petition for special leave to the effect that respondent number 225 are close relation has not been seriously challenged in the counter
This
affidavit.
is known to all. We know this.
Now, last paragraph, I'll just read it. When a civil litigation is pending for the property wherein the question of possession is involved and has been adjudicated, we see hardly any justification for initiating a parallel criminal proceeding under section 145 of the CRPC. There is no scope to doubt or dispute the position that the decree of a civil court is binding on the criminal court in a matter like one before us. Counsel for respondents 225 was not in a position to challenge the proposition that parallel proceedings should not be permitted to continue, and the event of a decree of the civil court, the criminal court should not be allowed to invoke its jurisdiction, particularly when possession is being examined by the civil court, and the parties are in a position to approach the civil court for interim order, such as injunction or appointment of receiver for adequate protection of the property during pendency of the dispute. Multiplicity of the litigation is not in the interest of the parties, nor should public time be allowed to be wasted over meaningless litigation.
Yes, yes.
So once, your lordship, he has approached the civil court, your lordship, He did.
Let's see the order of the district judge. At which page?
Before that, can you go through the order of the additional district magistrate, your lordship, that was put to challenge?
No, not required.
Lordship.
Let's see the order of the district judge.
Lordship.
This is the order you have
Yes,
impugned.
yes.
Mm.
That lordship will find at page number, it starts from page number 48.
Mm.
And the lordship will go to page 55. Paragraph number 7.
Mm.
Lordship has got it.
Yes.
On perusal of the impugned order dated 28/3/2025 and also the connected case record, it is found that the learned court will observe that the second party has proved the case by adducing witnesses and exhibiting documents, and hold that the second party was in exclusive possession of the disputed land since purchase, having valid right, title, and interest over the disputed land, and finally declared possession of the suit land in favor of the second party OP. It appears from the case record, the second party adduced evidence in chief of 3 witnesses, DW1, DW2, and DW3. Although several dates were given to the first party, but the first party failed to cross-examine the witnesses of second party. Thereafter, on 16/8/2023, the second party has filed a petition with a prayer to impeach certain other co-sharers of the disputed land in the case. But the learned court will rejected the said petition by order dated 28/11/2023 and finally declared the position in favor of the second party OP. After hearing the learned counsel for both the sides and after perusal of the case record, it appears that the second party presented evidence in chief of 3 number of witnesses, that is DW1, DW2, DW3, but they were not cross-examined by the other side. I agree with the submission that several opportunities was accorded to the first party, but the first party failed to cross-examine them. Another contention made in this case is that the first party revisionist side preferred a petition before the learned court bill on 16/8/2023 to impeach certain co-sharers of the disputed land for just and right decision of the case, but the learned court will rejected the said petition without reflecting any reasons for rejection of the said petition, which is illegal in my opinion. On perusal of the impugned order, it appears that the second party OP claimed to have purchased 10 cutters of land with separate boundary, but the learned court will declare possession over total 16 cutters of land involving the land of the first one with separate boundary. Before concluding, let me go through the celebrated judgment passed by this Honorable Supreme Court of India, reported in so and so. Considering the entire facts and circumstances, I am of the considered view that the case is remanded back to the learned court below to facilitate the first party to cross-examine DWs within 3 months from today. It is further right the petition that the petition that was
It is only remanded to cross-examine.
Lordship already, yes, cross-examine, that cross-examination closed way back in 2023. He has not challenged. 2023, the cross-examination was crossed, your Lordship. In 2025, when the matter was final, he only wants to prolong the matter. Since 2009, your Lordship, 2025, I have for this litigation, your Lordship, I have never made any default.
You are not in possession of the land.
I'm in possession, but I cannot start construction because he resides nearby. He goes and starts fighting, your Lordship. Therefore, your Lordship, that is the problem, your Lordship. Why this matter should be prolonged further, your Lordship? Once the title suit has, yeah, they are very right. He has to decide his title is by way of title suit. He has filed the title suit. He did not contest the suit, dismissed way back in 2016.
You can cross-examine, I think.
No, Lordship, that is totally your Lordship, your Lordship. Why cross-examination should be done, your Lordship? To what to decide, your Lordship? 145, 146 proceeding is for if there is any breach of peace, your Lordship, that is to be decided. Or if the court does not find out who is in possession of the land, that is to be decided. The court has clearly find out the possession of the land.
You have any supporting
Lordship,
judgment?
yes, Lordship. Here,
only to
learned session judge has not decided any right of the party. Learned session judge, I'd like to, Lordship, draw your attention.
I've read it.
Page number 57. Page number 57, para 11 of the judgment. Considering the entire facts and circumstances, I am of the considered view that the case is remanded back to the learned court below to facilitate the first party to cross-examine the DW within 3 months. And it is further directed.
You have any supporting judgment? It's okay.
Lordship, I would like to support Lordship, 2 judgments, Lordship. One, that this is not the abuse of the process of the court. That is Pradip Kumar.
No, this is revision only.
This is not an abuse, Lordship.
Criminal petition, okay.
This is the revision of the learned trial court and the.
It's not revision. This is criminal petition.
Criminal petition. So
You are asking for what? What is your prayer?
Whole proceeding.
The order of the ADM should be upheld, your lordship. He has rightly decided, your lordship. What illegality he has done, your lordship? If he has
No,
been
no.
given, even the learned session court has held in his order that several opportunities were given to him, but he did not cross-examine. Should the court wait, your lordship, till eternity?
Let us go to the order of the ADM.
ADM, that is what I am saying, your lordship. Lordship will kindly come to the order of the ADM, which is at page number 37.
Page 37.
Page 37. Suppose he has committed an illegal, he has not given any chance or.
Lordship, that order declares the possession of the other party. So I am being aggrieved. I have filed the criminal division before the learned session judge that I was not
No,
given the
let us
opportunity to
see,
cross-examine the
let us
PW.
see if you were negligent. For how many days you were negligent, let us see. Yes, the order of the ADM.
That
Page 37.
is not there.
Yes, please read it.
Third paragraph. The first party, lordship has got it.
Yes.
The first party adduced evidences which have no basis, having no any documents. The second party was examined, but the first party did not cross-examine the second party as DW1 and DW and other witnesses of the second party. The second party submitted evidences in chief as DW2 and DW3 respectively, but the first party failed to cross-examine the DW2 and DW3, although the first party got several dates to cross-examine the same. Later on, the evidence of the PWs were posed as per instruction of this court. At this stage, the first party submitted a petition for impleadment. After 13-14 years of filing of the case, the implead petition was not signed by any of the parties interested to get impleaded. Yes, sir.
This is the petition you have, that second party has filed.
Yes. Then when he did not, his cross-examination was closed, then he filed a petition saying that I want to implead some persons. But those persons who were supposed to be impleaded, they did not even put their signature in the petition. As such, the petition for impleadment was disposed of, and again recently the first party filed another petition for impleadment, which was signed by one Srimati Minara Begum, but the said Minara Begum has no land in this case as per the record. Moreover, the said petition contains no schedule of land and not supported with affidavit, and as such, the second party's impleadment petition also cannot be entertained in the meantime. After proper process, the date was fixed on 9/11/2023 for order, but the first party filed a petition for transfer of the case to the court of any other additional district magistrate, and the said petition was allowed, and the case is hence transferred to this court for disposal. Since then, the instant case is pending in this court for disposal, and as per order dated 28/11/2023, a police report is received which is in record, and the police does not support the case of the first party. So after perusal of the record, it appears that the
No,
first
there's so much of negligence.
Lordship.
No, 13-14 years.
No,
So much,
13-14
and
years,
then
Lordship,
title suit also you did not
No,
appear.
13-14 years, Lordship, that petition. There are two limbs, Lordship. One is cross-examination of the DW, and other is one petition has been dismissed without assigning any reason. That petition that may not be considered, Lordship. That petition I have filed as per the learned ADM, that after 13-14 years, I have filed the particular petition for arraignment from the co-sharers. That may not be allowed, but I may be allowed to cross-examine, Lordship, and that after perusal of all this and after scrutinizing all these materials, learned session judge has allowed me 3 months time, that I may be given only 3 months time. That particular order of the revision, that is not on merit, Lordship. That was remanded. The challenge, the particular.
But you see, negligence, 13-14 years is.
No, Lordship. 13-14 years, not for a cross-examination, Lordship. That particular petition, I have filed a petition for arraigning some of the other persons.
I understand.
So that may not be allowed. That may not be allowed. But I may be allowed to cross-examine, Lordship. I may be allowed to cross-examine because then only the learned ADM
So
can.
you were supposed to cross-examine in the case when it was
ADM.
decided earlier.
Lordship, I was for bona fide reason I could not cross-examine on that particular day. It was closed, and then I had been aggrieved. I filed another petition that was also dismissed. Then only I have challenged this particular.
Have you
order.
challenged that petition which has been dismissed for cross-examination? Which petition you have filed for cross-examination?
Lordship, after dismissal, Lordship, the learned ADM has already decided in their favor, and I have filed the criminal revision before the learned trial session judge. And learned session judge, considering on contest, Lordship, hearing both
But
the
you
sides
see,
taken
after
only
thir-
3 months time. Lord.
When did you file? That was also after 13, 14 years, that petition for cross-examination. When did you file?
No, I have not filed petition for cross examination, Lordship. I have filed a petition for arraying the co-sharer as a party, to implement the co-sharer as a party, Lordship. That may not be allowed. That is the.
But without a petition to allow you to cross-examine,
Lordship,
evidence has been closed.
I have filed petition, Lordship. That was this rejected, Lordship.
Where? See, that petition has to be challenged. Only then district judge can pass an order.
Yes.
Otherwise, district judge cannot pass an order to remand it back.
Lordship, I have, so far as criminal revision is concerned, I have challenged the final order of the ADM, Lordship. I have challenged the criminal revision. That is the provision, Lordship. I can challenge
No,
any
you
final
see-
order of the 145 and
Okay.
146 before
You
the
can
session closed.
see, you can challenge the final order.
Yes, Lord.
But while challenging the final order, this point has to be there that you were not allowed to cross-examine.
Yes,
Without,
Lordship, that was
the issue has to be raised while challenging. Without raising the issue, then you cannot come here with that issue.
Lordship, I have challenged all this, Lordship, and that is available in the judgment itself, Lordship. That
Let
was
me
the
see,
session
let me see.
judgment itself that was mentioned.
Where have you mentioned? Where it has been mentioned? But I must see the petition also. I must see the petition also. The petition for cross-examining after evidence was closed, the petition from, I must see the petition. Without the petition,
Not such a petition was filed.
They have this petition was filed by them.
He has filed an affidavit in opposition also.
Yes.
He has filed his affidavit in opposition.
That petition, for that petition, Lordship may call for the record also.
record
Because
is
that
there.
was
I
filed
didn't, I have the record. Okay, we do not have the record. We'll
Lordship,
call for the record that
Yes.
criminal appeals record, revisions record will call.
Then Lordship,
Where have you filed a petition?
Lordship,
Where have you filed a petition for cross-examination of the
ADM.
witnesses?
before
ADM.
ADM.
Okay, we'll call for the records from the AGM then.
Yes, Lordship.
Okay. Scan copies? Or you want the records?
Since
Check the bill.
disposed of records may also come.
Hmm?
Matter already is disposed of.
This will call for the records. Correct. Mr. Amish Loskar is present for the petitioner and Mr. D. Ullai is present for the respondent number 2. It appears that the records of this case number what? MR case number 190?
Lordship,
MR case number 190 M of 2009
2009.
is required to in connection with this matter call for the records of order of the ADM. Where is the order of the ADM?
ADM order. It's 37.
28, 3, 20.
Call for the original records of case number, MR case number 190 M 2009 from the additional district magistrate Kachar Silchar. List on, we will fix it on after vacation. You want a date?
Interim order may continue.
Interim order shall remain in force till the next date of listing. You can take this back,
Yes, I'll take.
the judgments.
Yes.
That is why I insist on records before hearing.
Yes, I also did not see that. That record was also not called for us.
Yes. And even I ask the parties also, do you want records? If the party said I do not want record in criminal petition, then I don't ask.
Yes.
But usually records are required.
Obliged.
In this case, we are appearing for the respondent. Along with you, my lord, this revision petitions, we have filed an IA for, my lord, enhancement of the maintenance that has been awarded by the trial court as well as the appellate court. What has happened, my lord? The petitioner being wife of the respondent. Sorry, I am respondent in this case. The appellant is my husband, petitioner. She filed a, my lord, a DB case before the Lagat trial judge, but stating inter alia that she has been, my lord, domestic.
List the matter on January DD. 7 January.
The interim order.
Interim order shall remain in force till then.
So can it be little later, that's on 9th?
Can be.
Yeah.
Timing item 16. Timing item 6. 16.
This is motion matter.
Yes,
Admission
admission.
relating to what?
Actually, the engaged counsel, he is like on another court. Kindly take the matter after some time. He will be coming just. I'll inform you. Okay.
Item 18.
My respondent number 1. Lordship, in this case, I need some instruction from my client, Lordship. So today itself the brief was handed over. And in the meantime, Lordship will file our affidavit. For which time is granted after vacation?
A date may be fixed, madam.
Yes,
For which, madam.
Learned counsel, Mr.
MM Zaman.
M.N. Zaman has prayed for adjournment. Full stop. Learned, for respondent number 1. For respondent number 1 has prayed for adjournment to obtain instructions from his client. Learned counsel, Mr. A. Manaf is present for the petitioner. Learned additional PP, Mr. B. Sama is present for respondent number 2. We'll call for the scanned copies of the record.
My lord, necessary, my lord, I think, my lord. I think, my lord, it is necessary, my lord.
Will be necessary.
Only, my lord, we are seeking, my lord, for quashing a.
Final
order.
Interim order.
My lord, it is maintenance case, my lord.
Final order.
No, my lord, it is not final order. My lord, during pendency, my lord, criminal maintenance petition, my lord, we, my lord, filed an application pursuant to order passed by this honorable court. And without considering the court's order, honorable court's order, my lord, this honorable court's order, my lord, in WBC number, my lord, 1389, my lord, this order has been passed, impugn order has been passed, my lord. And in fact, my lord, in WPC, my lord, in writ petition, my lord, the specific order was passed from the initial order, my lord, that is, my lord, 9/2/2011 till to pass of the Honorable High Court's order, maintenance allowance at the rate of rupees 2,500 should be paid. Without considering this arrear portion, my lord, our petition rejected, my lord. That's why, my lord,
They have mentioned a figure of to the tune of 3,63,150 rupees. Now, how they arrived at this figure, my lord, that has to be ascertained here.
my lord, it will ascertain by the court below, my lord. My lord, as my submission before your lordship, the family court should, my lord, should follow the instruction passed by this honorable court. And while passing the order, calculating of
But
the.
we'll have to hear him. Let us hear him. He is the one who will make the payment.
File our
My lord, my lord.
Obtain instructions.
Yes, we'll file our affidavit also in the meantime.
And also has prayed for time to file affidavit in opposition. Meanwhile, call for the scanned copies of the miss case number 635/2009 or any other case.
My lord.
MR case, miss
My lord,
case.
my lord.
What is the case number?
My lord, FC FC criminal
FC
305,
You don't have miscase now. FC criminal.
305 oblique 1995.
List after, immediately after the winter vacation? You want a date?
A date, my lord,
Okay, date it, did you?
9 January.
9 January?
my lord, my lord.
Last week of January.
No. She is a destitute woman.
My lord, he is a petitioner is a first wife, he is a second wife, my lord. Everything got, my lord. The service benefit, now maintenance, everything he is getting, my lord,
9 January.
my lord. Obliged, my lord.
Time being item 6. Item 9. Item 21. Bail hearing.
9.
9.
9.
Okay.
My lord, by this petition, my lord,
Hmm.
my lord, we have, my lord, challenge, my lord, a order passed by learned SDGM, my lord, issuing, my lord, warrant, my lord. My lord, what happened, my lord? Present petitioner and the, my lord, informant, they are the neighbor, my lord. Your lordship kindly see for a moment, FIR, my lord. Absolutely false FIR has been lost on personal grudge, my lord, page 9, my lord. Page 9. Just moment, your lordship kindly see. He is a married wife, my lord, having, my lord, children, my lord. Page 9, my lord.
You are asking for stay?
My lord, I will appear and contest the case, my lord. In the meantime, my lord, I may be protected, my lord. Since, my lord, a compromise has been given during, after filing of the FIR.
Okay, you appear then. Okay, let him appear. We will keep this warrant in abeyance. Listen, this is not a very old case.
Not all case, my lord. My lord, your lordship kindly see.
25. Let him appear.
My lord,
What is the FIR lodged?
my lord, FIR, my lord, laws, my lord. FIR laws, my lord.
2025.
Yes, my lord. And my lord, compromise, your lordship, page 16, your lordship kindly see. There is a compromise.
Then my lord, cognizance was taken.
Cognizance taken, my lord. My lord, one is one.
Second, my lord, please.
Okay, you appear. See, this is only 2025.
Very unfortunate, my lord. He is, my lord.
It's okay, it's okay. You appear.
My lord, I will appear, my lord. Next date, my lord, 18, my lord.
Learned counsel, Mr. A. Manop is present for the petitioner. Azaduddin Loskar alias Azad Hussain Loskar, who has filed this application under section 528 of the BNWS 2023, read with article 227 of the Constitution of India, with prayer for quashing the impugned order dated 22/10/2025 passed by the learned SDGM, within bracket S bracket close Kasar Silchar, whereby the court has issued bailable warrant of arrest against the petitioner in PR case number 1316 of 2025, arising out of Silchar PS case number 258 of 2025 under section so and so. Heard Mr. B. Sharma, learned additional PP Assam, who has accepted notice on behalf of respondent number 1. The petitioner is willing to cooperate with the trial. Full stop. It is submitted that a false case has been initiated against the petitioner, but even then the petitioner is willing to cooperate with the trial. Full stop. Unfortunately, warrant has been issued against him and the petitioner is apprehending arrest. Full stop. I have considered the submission that the petitioner is willing to cooperate with the trial, and therefore without issuance, no POSCO, no?
No POSCO, my lord.
And therefore without issuance of notice to the respondent number 2, this court deems it appropriate to direct the petitioner to appear before the court and cooperate with the trial. Full stop. Pragmatic view is taken, and thereby the petitioner is directed to appear before the court, before the jurisdictional court stroke Elaka magistrate on 18.
On 18, my lord. On 18/12.
18/12/2025 and cooperate with the trial. Till then,
I cannot be put into bar, my lord.
till then, BWA issued against the petitioner is kept in abeyance.
My lord, on that appearance, my lord, I may be allowed to go on bail, my lord. Otherwise, my
This
lord,
is not prayer for anticipatory bail.
my lord,
This much only, this, I can pass only order up to this limitation.
in my prayer, my lord, I have made a prayer, my lord. My lord, if I,
Anticipatory bail.
yeah, my lord, what happened when one
Even
section
if
is
you
a,
make a prayer, I cannot pass this order.
my lord, one section is a non-bailable section. If I appear, my lord, I will put in the bar, my lord. My lord, that's why, my lord,
You are the sole accused.
my lord, sole question.
See,
My lord, I'm the sole.
see, we are very cognizant of the fact how to deal with this type of case in case of sole accused persons. If you do not know the techniques, then I am not the one
My
to
lord,
teach you.
My lord, in fact,
There are ways how to not go behind bars. I think Nawaz will know because he was the magistrate.
in fact, my lord, there is a compromise, my lord. There is a compromise, my lord, he withdraw the FIR, my lord.
No, this court cannot help you.
My lord, exactly.
You'll have to help yourself.
My lord, only a single observation may be given. I left
No,
there, my lord.
no observation. I have given the best of the observation.
Oblige, my lord. Oblige.
Okay, one word I can, one line I can add. Till then, no coercive measures to be
My lord,
taken.
oblige, my lord. Highly oblige. Highly oblige.
Now discussion.
May I please, Your Lordship? May I please, Your Lordship?
Yeah, please.
So this is a matter where, my lord, the interim custody of the vehicle was granted. It was, my lord, actually, my lord, seized, my lord, in connection with an NDPS case. My
They
lord.
have filed an objection.
They filed an objection, my lord. Now, my lord, our case is that my lord, though the release was granted, my lord, the security amount, my lord, which was, my lord, put, my lord, is 15,000 as bank guarantee, 15 lakhs as bank guarantee. My lord. So therefore, our case is basically is, my lord, that this is a 9-year-old vehicle, and we have put the RC at page, my lord, 8, my lord. The registration, it's about 9-year-old vehicle, and the insured value is about 6 lakhs and odd, my lord. So, my lord, the amount of the 15 lakhs that has been fixed is, my lord, is an arbitrary rate, my lord.
It was already given the.
Zimmer was given, but my lord, 15 lakhs is an exorbitant price which we cannot, my lord, which you cannot, my lord.
What kind of objection do you have?
Saying that gravity of offense not to be
Bank guarantee.
Bank guarantee. That's it. Here also control.
15 lakhs, we can give other surety also, land surety. How can someone give 15 lakhs? I also do not have it.
Exactly, well, 15 lakhs bank guarantee, how can I provide money?
10 years. Recovered from the vehicle lordship, and petitioner was also involved. Lordship. He got
But there are secret chambers in the vehicle. Are there secret chambers?
Yes, lordship, and lordship petitioner.
No, but it was already given. You have not come against the.
Yes.
It was already handed over. Okay, that bank guarantee has to be changed to. I'll overrule your objection. I'll allow, I think. What do you, anything else? No.
Page 19, my lord, is an impugn order.
If there were secret chambers, then it was your duty to come against the order. But you haven't come against the order.
It's not there in the objection also that there are some secret chambers in it. It's not there in the objection. It said the vehicle was used. My lord, that's that, my lord, we have not, we are not on that matter. Since the vehicle has been directly released, my lord, the 15 lakhs bank guarantee, my lord, and that 10-year-old vehicle, my lord. And we have given the insured value also, my lord. There were some parameters, my lord, are there, my lord.
What is your prayer, to reduce their bank guarantee or to reduce the bank guarantee?
Reduce the bank guarantee, Lordship says.
How much to how much?
Any
6
other
lakhs?
security, 6 lakhs.
6 lakhs. Let us reduce the bank guarantee to 6 lakhs from 15 lakhs to 6 lakhs. You have not mentioned anything in your prayer?
No, we have said that.
Only to set aside the provision.
Yes, we set aside.
Condition of providing bank guarantee of rupees interim custody of the vehicle. Okay, we'll make it to reduce the bank guarantee and make it to 6 lakhs. Heard Mr. M. Dr. Lanak, counsel for the petitioner. Who has filed this application under section 442, read with section 438 of the BNWS 2023 against the order dated 1/9/2025 in NCB crime number 3/2025 within bracket NDPS case number 81/2025. Heard Ms. M. Deca. You are a standing counsel or you are on? heard learned counsel Ms. N. Deka on behalf of learned standing counsel Mr. S.C. Kayal, who has raised objection, and objection has also been filed against the petitioner denying the declared insured value as conclusive or decisive. Full stop. The petitioner submitted that the declared insured value of the vehicle is rupees 6 lakh 6,06,893, whereas the condition for bail was an enormous amount of rupees 15 lakhs as bank guarantee. Full stop. The petitioner has prayed to set aside the order imposing bank guarantee at the rate of rupees 15 lakhs to be furnished as surety by the petitioner. Any supporting documents?
Yes,
relating
madam,
to
the
insurance?
the insured value I've given, madam, that insurance policy, madam, that page
That is
22, madam. And my lord, the RC of the vehicle, it's a 9-year-old vehicle. Page 8 is the RC. And page 22 is the my election, my lord, the insured, my lord, insurance, my lord, policy, my lord.
Page 8. Page which? Where is the RC?
RC is page 8, my lord. This is a virtual RC, my lord. It was a 2015 vehicle. Vehicle age is 9 years, 11 months. Page 8, my lord, annexure 1.
It is submitted that the annexure 1 of the vehicle clearly reveals that the age of the vehicle is 9 years and 11 months.
Yes.
So it is further submitted that where is the declared value?
Declared value is the page 22, my lord, and the type copy is page 22, my lord.
Annexure
Annexure, my lord,
5 of the vehicle
5.
clearly reveals the declared value of the vehicle at the rate of rupees. Where is the amount?
my lord, this page 23, actually, my paint is not very clear. That's why we typed it out, my lord. Page 22, my lord, 6,06,893.
6,06,893. Full stop. I have considered the submissions at the bar with circumspection. It appears that the petitioner has Miss M. Dekajigat. It is also submitted that the vehicle was involved in a serious heinous offense of transporting methamphetamine tablets. What is the spelling methamphetamine? Seven point 473 kgs of more cortisol. methamphetamine methamphetamine tablets. After considering the submissions at the bar, it appears that this court deems it appropriate to reduce the amount of bank guarantee from rupees 15 lakhs to rupees 6 lakhs. Thereby the impugned order dated 34, no?
Madam.
34/2025 passed by the learned session judge.
No, madam, sorry, 1925, madam, sorry.
19/2025 passed by the learned. - 1925 passed by the learned session stroke special judge Silchar. Directing the custody directing the IO to release the vehicle in Zimma to the registered owner is after examining all the original documents is modified and the bank guarantee is reduced from rupees 15 lakhs to rupees 6 lakhs. In terms of the above observation, this petition stands disposed of. Short submission, anybody can make short submission. For adjournment only, huh? But not for next week, that will be a long submission.
I would like to mention, my lord, item 27, my lord, the same similar matter, my lord, item 3. I have already moved and that is notice has been issued, my lord. Item 27, my lord.
Okay, will issue notice,
Yes,
item 27.
and call for the case record
Okay.
and notice to the respondent number 2, my lord. Call for the case record and
Item 20.
that is from, my lord,
Item
27.
27. Okay, we will issue notice to respond number 2.
Yes,
So
my lord.
the scan copies of case record or for
Scan copy, my lord.
disposed of
Trial court
case?
record, yes, my lord. That's all.
Disposed of case
No, my
or
lord.
the pending case?
Pending case, my
Scan
lord.
copies of trial court record. We have
From
PP.
Kamrup Amingao.
PP.
Yes, my lord.
Learned additional PP, Miss Andas has accepted notice on behalf of respondent state.
Respondent state and
And thus no further notice is required to be issued.
respondent number 2, my lord.
Notice to respond number 2.
2, my lord.
It will liquid once.
9 January.
Yes, my
Same
lord.
day.
9 December. Obliged, my lord. March obliged.
Sir, item 21 CD not received.
21 CD is not received.
Interview there.
TDS call for is not received. Issue reminder, list the matter, Lombard date.
January.
Interim order shall remain in force till then.
Okay.
You are the informant. Why are you so worried? Stay. Criminal petition.
Bail petition.
AB. Oh, you are the informant, okay. The learned counsel for the petitioner, learned counsel for the petition, Mr. S. Chauhan is present. Learned counsel, Mr. Huh? S. Sharma is present for the informant and has raised serious objection as the prosecution has failed to produce the CD. Full stop. The petitioner, learned additional PP Miss Andas is present, who's a prosecution to produce the CD positively on the next date fixed, list the matter on all of short date video. Mana generated video. Interim order shall remain in force till then. Okay, I have reduced his stay.
May it please, your lordship, madam, item number 28. My friend is appearing.
Item number 27 asle last 21 asle. Yours is 28.
28, my lord.
Yes.
My friend is appearing for the amicus query.
An appeal against acquittal. It's come for order, so it may be fixed for hearing, my lord.
Hearing, but
We have the LCR.
Record that is. The
Okay.
only thing, my lord, is that the registry has not provided me with the appeal memo. And now since TCR has also come, my lord may just direct the registry,
Yes.
furnish me a copy of the appeal memo and all the relevant documents from the TCR. So that will be- so that will be difficult.
Yes, it will be difficult.
Yes, my lord, as per my learned, since continue.
Learned counsel, Mr. P.K. Rochudry is present for the appellant and learned amicus curiae, Mr. S. Nawaz is present for respondent number 2 and has submitted that he has not been provided with the copy of the appeal memo, full stop. Registry to provide the copy of the appeal memo along with the relevant documents.
From the TCR.
Yes, from the TCR. Learned additional PP, Miss N. Das is present for the respondent state. As the pleadings are complete and as the record, we have the trial court record. List this matter for hearing after vacation.
Well,
Huh? After winter vacation. Our nine, no?
Have to disturb your lordship a must because only praying for a similar order which is available at page 46, my lord.
Page 46.
Yes, my lord. One of the co-accused has already obtained a stay order and issued notice, my lord. So see, I pray for the similar order, my lord, and it is fixed on 16th, I believe. The main case is now fixed on 16th. Last para amplifies everything, my lord. From violation of the mandatory provisions of law, because under the new BNSS, my lord, nowadays, before making an accuse, notice is to be issued under certain conditions, my lord. That conditions were violated and there are laws from the other courts, my lord. So on availing on that, my lord, the Honorable High Court stated. Para 13, my lord, page 50. Same case, my lord. In the meanwhile, considering the submission made by the learned counsel for the petitioner as discussed in the foregoing paragraph and the importance of the issue raised in this criminal revision, further proceeding of complaint
This
case.
is not the same case, no?
My lord.
Same case, yes.
Same case, same case.
Same case.
Same case. I'm the co-accused in this case.
Oh, you are the co-accused. One is Manoj Chauhan,
Mona Chauhan.
which we have been noticing.
Your lordship,
day.
coordinate benches already gone. Right.
And the other, this
These
petition.
are the printer and publisher of the Ahomia Protidin, my lord.
Oh, Jayanta Borba,
No.
that
Yes.
Protidin Malik.
Protidin, yes, my lord.
Okay.
He's the
Anybody,
proprietor and editor of Protidin.
anybody from this side?
No, my lord. Actually, this is a complaint case, my lord.
Only a complaint case.
Issue notice and stay may be granted, madam. And fix with this criminal petition 1384. Page 46.
Passed by the learned CJ, Guwahati in complaint case number.
Kamrup Metro got
um,
78 of
this was,
25.
Published in that his newspaper.
Yes, ma'am.
Okay.
I have published.
Complaint case under section 500.
Yes, madam, IPC. Madam.
Okay.
But nowadays the new procedure has come in.
Ah.
My lord, you will know, my lord, 233, that you cannot directly make a person an accused. Now we have made a new, coined a new term, proposed accused, till cognizance is taken. So here that procedure was not followed, my lord. And the other High Court, there are no judgment from Supreme Court, but High Court has passed certain judgment which is also quoted and we have also quoted it.
I know that day somebody came,
How?
then order of cognizance was taken.
Not taken, my lord. Proposed accused, before taking cognizance, my lord, notices are issued. So what you have got to say, come and say. So we have pointed out the fault committed by the magistrate. So he said, no, there is no fault on my part. And accordingly, he has passed the order that I will going to examine and take.
That day, you see, I have not passed a stay in another case,
But this is the
as-
same case.
Not as.
This case.
Same case,
Yes.
same type of case. I have not issued stay because you see, order of cognizance is an order.
No, here I have been issued notice.
Issue notice is an interlocutory order.
No. Here I have been asked to come and say whether cognizance should be taken or not. So I have appeared. Now I have pointed out the technicality false because the law is yet to develop. BNSS has not developed yet, my lord, because certain new provisions have come in. So accordingly, probably the CGM has missed it. So Allahabad High Court, Kerala
What is
High
the
Court.
order of the CJM? Let me see. The
My
order
lord.
of the
Yes.
CJM.
What a page. My lord, this is at page 42 and Annexure 4. And the first order is at page 37, my lord. Your lordship will be better academically to see page 37 first.
It's already stayed, my lord. There's nothing. It will be hard on the 16 and disposed of.
Actually, I don't see any wrong in the order according to the
No, no.
BOP.
This is the order issued. Now the impugned order comes at page 42. We are challenging page 42 order. We are not challenging this order. Because law has been settled by the Allahabad High Court, Kerala High Court, or probably Rajasthan High Court, Karnataka. That procedure has not been followed. So we have to correct that procedure, madam. He cannot review his own order also. No harm will be caused to anybody. My lord, only thing is that it is already stayed and already fixed on
I know.
16. So we'll just join in, my lord. That's the purpose.
I know, I understand.
Yes, my lord. That much so. Let the law now be fresh, my lord. So most of the courts are not aware. We also reading all this judgment could get the grip, my lord. Yes, this is the law. Now, how much it will be correct or not, because our High Court may take a different view from
Yes,
Allahabad
yes.
High Court. So it will be only decided at the time of hearing, my lord.
I do not find any error in this order.
No, no, it's not the question of error, my lord. Now I'm coming on the proprietary. We are not hearing it. I have not argued it, my lord. Why, how can your lordship decide that no error is there? I have to show. But I am asking, my lord, a similar case, accused persons, already there is a coordinate bench order. So if your lordship is having problem, my lord, then let it put it before the appropriate bench.
No, no, I can pass an order to.
I want that only, my lord, so that we can join on the 16th and we'll hear it. Just because somebody complainant is something, my lord, that should not be, my lord.
No, 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 no.
Oh, that,
No, both are.
that I want
you
to
see,
rule out.
yeah,
my lord.
both
I
are
am on the
equally
law
important.
points.
Both
Right
are
and wrong.
equally important
No,
for the
my lord,
court.
right and wrong will come
No, no, this
when I will
is a
place
way-
my
way-
case. my lord.
Argument is this.
No, no, my
Both
argument.
sides are equal for the
No,
court.
no, my argument is this, your lordship has given a comment that there is no wrong in the order. Well, I have not submitted itself, how it is wrong.
I do not find any error to
No,
stay.
that's your lordship view. Now, if I am given a chance, I will satisfy your lordship that it is wrong in view of this.
So see,
So let it come up for hearing.
It
That
has-
is my contention.
It has come out in a.
It is already
different way.
stated, even if I don't come up, my lord, there is no harm in my
It has
case.
come out in a different way. I am saying there is no
Ah.
ground to, no prima facie case to stay.
No,
That is what I.
That is
meant.
already stayed. In any case,
In
it
other
will not
cases-
proceed. In other case. This case is at your lordship pays
But
46.
so far as the Manoj Chauhan
That's
is
your
concerned-
view, my lord. When we will hear it at length,
No, you
then
see-
we will give everything.
You see, no, both are equal for the court. I'm
Right.
not that type of court that I will give
No,
importance
ठीक
to
है, your
the
lordship is
complaint
very
and
fine,
or
my lord.
less
No,
importance.
no.
Both are equally
Had
important.
it
for
been
the
in the same, not in the same case, as a precedent I have used, your lordship may refuse for it. I have got no issue.
No, I won't recuse. Why should I recuse?
No,
I will deal with
no.
it.
I'm pointing it out. If I don't point out, my lord,
I will deal with it.
no, I'm just pointing it out because same case, same points.
No, whatever you are saying that you got me wrong. I'm saying that I'm not finding any error. That is not what I meant to say. I am saying that I do not find a prima facie case for stay. That's what I meant. to say.
My now reply to that will be, my lord, that in a similar situation, same case, same accused set of accused person, for one already it has been stayed. So that is fixed.
And I
in
must
16.
respect the court of order of
Or
a coordinate
coordinate
bench.
bench. That is at this
That
stage,
is
my lord.
true.
Subsequently to your lordship.
I should ought to respect.
My only submission, when it will take place on a hearing form, my lord, then your lordship may differ. That's a different thing. But right now, we are in the motion stage.
No, I'm not differing, but stay regarding stay. You see, the entire case is not stayed.
No, state, my lord, all state, my lord. I have joined in because even if I don't come, my lord, there will be no harm because all
So
the.
let's see the order passed by this court, last part.
My lord.
Stay order.
Yes, my lord. In the meanwhile, considering the submission made by the learned counsel for the petitioner as discussed in the foregoing paragraph and the importance of the issue raised in this criminal revision, further proceeding of complaint case shall remain state till
It is
return.
already stayed.
Already
So I
stayed.
cannot do anything.
Oh, only the accused are different here.
That line was not shown to me.
I'm sorry, my lord.
That is what
I
this is
read probably your lordship mistake. I read only that pair only. My lord, now only question is that it is fixed on 16th.
Well, stayed. This case is stayed.
Stayed, my lord. That is
I'm
what.
I'm not the appellate court of the coordinate bench.
So it's a heavy misunderstanding, my lord. I'm sorry, my lord.
I thought it was stayed only so far.
No. The whole case, because the law point is involved, my lord.
So I was reading and
I'm sorry, my lord. We missed this.
Had this line been shown to me, that entire proceeding is stayed.
Then nothing would have come up.
Trouble to read.
Absolutely, absolutely. So I read actually, my lord. Somehow we missed the line.
Stayed. Coordinate bench has already stayed.
Yes.
I cannot sit in appeal against the order of a coordinate
Sure, right,
bench.
my lord. That's true, my lord. I'm sorry, my lord.
It's okay. Item number 2.
6, my lord. In the morning, I could not be on time, my lord.
No, it's okay. Learned counsel Mr. Z. Kamar is present for the petitioners.
Yeah, petitioners, my lord.
Petitioners.
First is the editor and printer of Protein. Second is the publisher.
Borua, Jotin
and the
Chowdhury,
complainant of
Asomia
the chief minister.
and Asomia Protein team. Actually, this is not the first time they are. I have, as a lower court magistrate,
my lord.
I had several cases of this protidine, complaint cases of this
Oh,
protidine.
because
in my
see, my
court.
lord, they are
Everybody, they
Actually-
file cases against them.
they are.
When
I have.
print anything
Yeah,
in the
no,
newspaper.
I got it, man. Why they have to come, my lord? Because they publish some interview.
I know.
Suppose this Manoj Chauhan
I know.
said something against our honorable chief minister, something. Honorable chief minister felt agreed,
I
so
know.
he has filed his complaint. But
And
only
because
thing
we
is
have
that, my
marks-
lord, we are saying that we have printed and published like other press the same thing, but why we are targeted? That is the question to come
I
in the
understand,
hearing time, my lord.
because newspapers are always before the court.
Court,
In
yes.
complaint cases under 500.
Because they are the publisher, my lord,
Yes.
printer.
Not only protidine, there are so many
So many.
newspapers.
But protidine is facing the highest I've come to know.
Yes, I have come across 2-3 cases as a magistrate.
Absolutely.
2-3 cases minimum.
Right.
And then the other cases are against Janambhumi and others.
Janambhumi less, my lord. For Upper Assam, they write good things. Here, all masalas be dead, my lord.
Yes, there are many cases. And I have acquitted also.
Nowadays, more defamation in social media platforms, the digital
Mm.
platforms and all. Because writing needs some good mind, my lord.
Mm.
But here we have only published the interview which he has given in a press conference, like all other printer publisher of other newspapers. But we are only targeted.
Include this order page.
Page 50 is the way, 46 it starts, my lord, and ends, the stay is at page 50, my lord. Because I also want, my lord, that trial court will not face difficulty if the law is settled as to how to proceed in a complaint case when the first notice is issued. He is not an accused, he is a proposed accused.
Court doesn't have any.
No, nothing, my
judgment,
lord.
But
This
it
is-
will come soon.
Yes, first time, my lord. That's why the difficulty.
It will
my lord.
be it will be.
Now, if the
understood.
law is settled, my lord, then magistrate courts will not face troubles, my lord.
Yes.
So it should be settled, my lord. That's my response.
It must go before a DB.
That's
maybe.
why I have come. Otherwise, it is stayed.
That
that's
day they have
nothing much.
given me judgments of Allahabad High Court, which you are
Yes,
referring
yes,
here.
my lord.
They have given me,
I have given it. my lord.
but I didn't stay there. So that is one hurdle, because
No, that-
I must treat
that,
everybody
madam,
equally.
We can take up with the registry and fix all the matters together.
Yeah.
So the court will have an opportunity to hear all the various counsels. Then we'll take a final call, my lord.
But this has already been stated, so there is no.
Yes.
no
Now,
problem.
whether the Honorable Guwahati High Court will agree to Allahabad, Kerala, and Karnataka, that's up to your lordship. my
After
lord.
reading, we can agree maybe.
Absolutely, we may not
because
agree.
We'll come to know certain.
Because this is not Supreme Court judgment, High Court judgment is same, similarly your lordship
Yes,
is paid,
no, but-
only have got certain persuasive value.
But something you see, that may not strike us.
Oh, absolutely,
We may not
absolutely.
notice.
Your
which
lordship
the
will
other
differ.
court, other
No
court
doubt
have
of it.
noticed while
Other High
interpreting.
Court precedents are not binding in this.
No, but sometimes we can accept, because you see, sometimes we may miss some. If you read between the lines, sometimes
Yeah,
we may miss something,
that is there.
and then which has come to the notice of the other
Right,
court.
my lord.
It will paragraph 2 লিখি দিবা, huh?
13.
You have not made them a party?
No, my lord, not necessary, complaint case, my lord.
Okay. অকল জেড কামাৰ লিখি দিলে হৈ যাব, তাৰপিছত ফৰ দ্য পেটিশ্যনাৰ্ছ নামখিনি লিখি দিবা, তাৰপিছত তুমি লিখি দিবা নাম্বাৰ পেজ 47 পেৰাগ্ৰাফ নাম্বাৰ 2 নামটো চেঞ্জ কৰি দিবা, হা?
Only name will get changed.
ইয়াত এজন পেটিশ্যনাৰ আছে, বাকীখিনি তুমি হেৰি লিখি দিবা, মনোজ চৌহানৰ জেগাত বাকীখিনি নাম লিখি দিবা, 3জনৰ নাম।
Same thing will come up.
তাৰপিছত তুমি পেৰাগ্ৰাফ 3 একে লিখি দিবা।
16 December is coming. Let it be tagged, my lord. That will be better, my lord.
Okay. Same.
Tagged with this criminal revision
Yes,
number,
yes.
criminal petition number 1384. 46 page.
The cases are same, then it will be tagged.
My lord. One line, your lordship.
Para 4 লিখি দিবা। বাকীখিনি নালাগে।
Para 13 is the ultimate para.
বাকীখিনি
At
নালাগে।
page 50.
This case has already been stayed by an order dated 11/11/2000 and this
Past
case nalage, this case nahoy de, the complaint case number 78/2025
78.
has already been stayed by this court by order dated 11/11/2025 in connection with para 4 likha apni it last likhi diba,
4 will do.
Criminal petition number 1384 of 2025.
4 and 13 is the ultimate paras, man.
issue notices to the petitioners returnable on
To the
10
OP, my,
or to the OP, to the
sole OP.
to the sole respondent returnable on when is the
16
date?
months.
16 December. List this matter along with
Along with criminal petition number 1384, my lord.
Okay.
1384 of 25. Bracket of Manoj Chauhan versus state. I'm sorry, my lord. Sometimes misunderstanding happens.
I also didn't notice the last
Yes,
time.
my lord.
Item 24, where you are.
That is the lordship.
Mm.
FIR page 8, lordship.
FIR which page?
Page 8, lordship. Translated copy.
LCR.
Scan copy is
Okay. Yes, please.
Lordship, this is that the main accused person has already been granted bail, lordship, by the trial court. He was arrested and subsequently he got bail, lordship. And
Please read the FIR.
yes, lord. Sir, I have the honor to inform you that on 17/4/25 at about 9 p.m., my son, Pragyan Daimari, 19 years, while going to a neighbor's house, Mukutnath, son of Uttam Nath, village Uttar Raungar, PS Udalguri, along with Sri Pankiraj Doimari, son of Philip Doimari, village Bhuraka Suburi, PS Udalguri, came with a bolero car and wrongfully restrained him, and they beat my son, Priyaranjan Daimari, in his face and head and kicked him in his stomach and seriously injured him. Thereafter, my son returned to my home and verbally told me everything. On 18, there is a typographical mistake, lordship. It is not 14, 18. On 18/4/25, my son went to return to his work, but he could not and sleep in his bed. As injury and pain increases, on 19/4/25, my son was admitted to Udalguri Hospital and CT scan and X-ray were done. Thereafter, after preliminary treatment, doctor allowed him to go home. During treatment on 24/4/25, while Pragyan went outside the home, he felt stomach pain increases and fell down on the path, and later on 9 to 10, he died. Therefore, Your Honor may take appropriate steps against Mukutnath and Pankiraj Daimari and impose some
Yes,
appropriate
yes.
sanction on them.
Charge sheet has been submitted.
Charge sheet has been submitted, lordship.
You are shown as absconder.
On the lordship, in this case, lordship, charge sheet was submitted on 105 BNSs.
Mm.
BNS, and that FIR was 103 BNS.
105 will be
Culpable homicide not amounting to murder.
304.
Yes.
What is your name? You are not.
I mean, I'm Pankiraj Doimari, lordship.
You are Ponki.
Pankiraj Doimari.
And eyewitness statement of eyewitness their lordship implicated this petition and so many days last day 25, 9, 21, 5 days is acted. And NBW issued on 12/8/25 lordship. And lordship kindly paves the PM report also.
But this rejection was done by the trial court, lordship, not by the high court, lordship.
No, it's okay. I have earlier rejected his bail application. I have earlier rejected.
Earlier rejected. I'm
Yeah.
not aware, lordship.
You'll have to get new grounds.
Okay.
See, during investigation, I have rejected after going through the statements of the witnesses. Now what to do? You'll have to get new grounds. That charge sheet has been submitted. This is not a good ground. This is not a new ground.
In fact,
In
what
fact, it makes the case against you even stronger because charge sheet has been submitted.
Okay, Lordship, kindly see the charge sheet, page 18, Lordship. For a while, Lordship.
In the lower court, in the this scan copies of lower court records, they have sent my order.
I'm not aware.
Yes, yes.
I'm not aware.
Yes,
Lordship,
yes.
a last paragraph, Lordship. However, intention was not committed to murder. There is no intention to commit a murder. That is why, Lordship, 105 was.
Okay, I'll see the statements of the eyewitnesses then. Yes. He has, maybe intention may not be there, but he was assaulting him.
That is assaulting him. There is no such intention.
PM of Lordship, three-seam bruise is seen in the left lower abdomen. Cause of death is due to hypovolemic shock sustained due to splenic laceration with a circulatory.
PM report, no? There are eyewitnesses, they have been assaulting him and then they were asked not,
As
One person can.
many people tried to prevent also the assault.
sorry, Lordship, as charge sheet was submitted, that means Lordship, investigation is over. So I will cooperate with the investigation. I will cooperate with the investigation.
Doesn't appear because you didn't cooperate last time.
Last time.
During investigation, then again notice and NPW were issued against you.
Now I will cooperate, Lordship. At any condition. I will
And then
cooperate.
people asked you not to hit him and then you kept on hitting him.
Actually, Lordship, Mukutnath man.
Neighbors asked you not to
That-
assault
that
him
is-
and but you kept on assaulting
Actually,
him.
Lordship, that Mukutnath, Lordship, that is the main accused person.
No, equally. Equally, because this petitioner did not know, but eyewitnesses have named you. Otherwise, bail would not have been rejected in the first place.
I cooperate, Lordship. Lordship, allow me. Stringent condition, Lordship. Any condition, Lordship.
No. You didn't cooperate earlier.
Earlier not cooperated.
Four centimeter into 3 centimeter. Look at the size of the bruise. Left lower abdomen, lateral aspect. 4 centimeter into 3 centimeter bruise. Left lower abdomen, lateral aspect. 4 centimeter into 3 centimeter. Parietal cavity is filled with blood clot. Lateral surface of spleen is found to be lacerated. Spleen laceration. So I think it doesn't deserve anticipatory bail. I'm rejecting it. You want to see this number 2, item number 24. Third learned counsel, Mr. 24. Your name?
Yes, Sharma.
Yes, Sharma, for the petitioner. Somebody else's name is reflected here.
The W Raman. Well,
Okay.
my name is not reflected.
Mr. Esoma, for the Mr. Esoma as well as learned counsel Mr. W. Roman for the petitioner. Pomki Dormari alias Ponkiras Dormari, who has filed his application under section 482 of the BNSS 2023 with prayer for pre-arrest bail as his apprehending arrest in connection with so-and-so PS case number so-and-so under section so-and-so. Heard Miss Endas Learner additional PP Assam. The allegation against the petitioner is that he is involved in the assault which resulted in the death of the victim. "19-year-old victim, Priogon Doimari, full stop. It is submitted that the petitioner had no intent to commit the murder of the victim. Full stop. It is submitted that now that charge sheet has been submitted, the petitioner is willing to cooperate with the trial. The learned additional PP has raised serious objections stating that the petitioner did not cooperate with the investigation, which resulted in the charge sheet showing him as absconder. Post it is further submitted that several dates were fixed for appearance of the petitioner and warrants have already been issued against him. But even then, the petitioner failed to appear. It appears that the petitioner's submission that he will cooperate with the investigation appears to be bleak. Full stop. I have considered the submissions at the bar with circumspection. I have also considered the scanned copies of the trial record and I have scrutinized the same. Full stop. I have considered the gravity of the offense under which the petitioner is booked. It appears that the petitioner trial may be adversely affected if the petitioner is enlarged on bail, at this stage. Full stop. Nalage, it appears the trial may be adversely affected to Nalage. Considering the submissions at the bar and considering all aspects, this court is hesitant to grant anticipatory bail to the petitioner at this stage. Hence, petition stands rejected.
Item number 25 for orders.
May I please, Your Lordship? Your Lordship, item number 25 and 26, in both the matters, the earlier notice was issued and we have taken the steps during Corona time. So we may be allowed to take the fresh steps.
Okay. Long time back you have
Long
taken
time back.
steps. Okay.
It was taken on,
Long
reflected on
pending case.
long pending.
Okay. Learned Counsel, Mr.
R.A. Mazumdar on behalf of D. Hussain.
R.A. Muzumdar on behalf of
D. Hussain.
is present on behalf of Learned Counsel Mr. D. Hussain, it is submitted that steps have been taken long time back and the petitioners may be allowed to take fresh steps, full stop. The petitioners are allowed to take fresh steps to issue notice to the respondents.
Yes.
List after 4 weeks.
4 weeks. A date may be fixed.
Oh,
After,
okay.
after
This
January.
matter on data video.
On 20 January.
We'll call for the records.
Call for the record.
These are disposed of cases.
Disposal of cases.
Call for the trial court records.
Respond number 2. Here. Oh, IA. In IA notice is going. In IA on.
Only in IA.
IA.
Both the
So,
cases.
yeah, so TCR is not required at this stage.
Record na lage. Call for the records na lage.
In 25 and 26 both, Your Lordship. Oblige.
Item 29.
May I please, Your Lordship? My Lord, notice had been issued, and my Lord, efforts has also been taken from our part, my Lord. But the service could not be completed, my Lord, and My lord, matter relates to POXO. So, my lord, the appearance of this informant is required, my lord.
Yes, yes.
So, my lord, one thing is there, my lord, there is some misunderstanding while the FIR was lodged. Later on, my lord, an affidavit had also been executed between the informant and this, my lord, present petitioner, my lord. And that affidavit we have made as a part of a record at page 44, my lord, annexure 7. Now, my lord, the case is in a stage wherein, my lord, the proclamation of the property has also been, my lord, can see, peruse the last order of the trial court, my lord. Learned trial court is at page 43, annexure 6, my lord. It is in the appearance stage, but my lord, I am not on bail, my lord, admittedly. That's
I
why,
understand.
my lord. So, my lord, what has happened, my lord, the love affairs was there, my lord, the age is underage, my lord. My lordship is well aware, my lord, recently a judgment has been delivered by the Punjab and Haryana High Court, my
But
lord.
Supreme Court also.
No, Supreme Court has also held, my lord, that the Muslim minor marriage age, my lord, has been held to be 15 years if she attained the puberty and if the marriage is not by force. Then under the person,
No, not by Supreme Court.
my lord,
Not by Supreme Court.
No, no,
But
no, no,
love
my lord.
affair judgment has been passed by Supreme Court.
No, no, my lord, the,
It off koile na.
my lord.
We'll have to issue notice. To
No, my lord,
respond
no.
earlier.
Well, it was.
If there is a case for interim stay on the first day itself, a long order was passed, but nothing was taken up.
Yes, my lord. So, my lord, I praise this man for consideration of indemnity.
No.
Lordship goes to the affair, absolutely nothing against me, my lord. Can see the affair, my lord, at page 23, my lord. That has been filed by labor inspector, my lord. In inviting reference, I would like to draw your attention to the accident which occurred in so-and-so vehicle bearing number carrying people from Halmari Tea Estate lost control and fell down. In this regard, I would like to mention that carrying persons in goods vehicle is unauthorized as per the relevant provision of MV Act. Moreover, District Commissioner White so-and-so dated so had banned the carrying persons in goods vehicle using powers as per provision under section so-and-so of the Disaster Management Act and relevant provision of the Assam Disaster Management Rules. I would therefore request, my lord, kindly see the Goleshwar Gogoi. He is the contractor. He is the overall responsible, my lord. I am just the general manager of the tea estate, my lord. And more so, my lord, in the charge sheet, my lord, 36. Page 36, lordship, may kindly see the charge sheet, what has been written. Nothing against me, my lord. The mid portion, my lord, second paragraph. পদকিয়া শ্রী প্রেম শঙ্কর উঝা পিতা সহিংস নিবাসী প্রতিবেদন প্রেরণ করো এজাহার পদকিয়া শ্রী প্রেম পিতা সহিংস হুদপুষ্ট অন্তর মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয়ৰ নিৰ্দেশ মতে জামিন যাবলৈ হ'ল আৰু নাথিং against me, my lord. জব্দকৃত টাটা গোল্ড, this particular vehicle is not in my name, my lord. গাড়ী পঞ্জীয়ন সহিংস জিলা পৰিবহণ বিভাগ মহোদয়ক যোগেদি যান্ত্ৰিক পৰীক্ষা কৰিব পৰীক্ষাৰ প্ৰতিবেদন সংগ্ৰহ কৰি ইমান জক্ষীগণক ক্ৰমে nothing against me when I charge sheet also. Why I am charge sheeted? Why my name is in the affair, my lord? I am at loss to understand, my lord. So, my lord, unnecessary, my lord.
Can we say that?
Yes, my lord. Yes. Why they are reluctant? Actually, my lord, police demanded money, thinking that I am a rich man, my lord. Just because I could not fulfill that, unnecessarily made me accused. So what, my lord? No stay. No, my lord. I am innocent, my lord. No way connected with the labor. Also see the large annexure, my last page of my lord, page 38, my lord. The Goleshwar Gogoi, he has the overall responsibility of doing all this, my lord. I am no way connected with this case. Just I have said, my lord, money was demanded from me. I could not fulfill. I said, why should I pay? So then unnecessarily made me accused, my lord.
You are the owner of the vehicle.
No, nothing. I am just the person to whom the delivery was to be made. The independently contractor was there, my lord. Affair says itself. Page 23.
Permission, my lord.
That is not my lookout, my lord. Permission, everything is the contractor, my lord. Affair says nothing. Churches said nothing, my lord, against me. Goleshwar Gogoi, just now I have showed charge sheet, nothing in my name. Prem Shankar Uja so-and-so, মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয়ে নিজৰ মতে জামিন দিব লগা হ'ল টাটা, then what is my culpability?
My lord, this is a fit face for quashing, my lord.
There are
I'm,
persons injured.
I may not be unnecessarily, so I am not the driver, my lord. Neither I am the driver of the, nor I am the owner, I am connected with the business, my
Page
lord.
23 minor. Page 20 minor. What happened minor? Attention that this that is second, third line. Here list number 2 and 2. Carrying people from Almaty Estate. He is the manager, madam. Almaty Estate.
So what? That contractor is
Let
responsible.
me submit. In the first occasion, you are not given the interim.
My, why is so that energetic? I don't know, my lord. Nothing is in the case.
Almaty Estate lost control and fell down. In this regard, I would like to show you, madam. Here they have made the party in the manner FIR also, madam. They are in interim. They are in the bail manner. And in the last of the lordship was pleased to issue notice to the respondent, my lord.
There is
Then
no
they are
ground.
not given the interim protection on the first date. On the
You're on bail, no?
bail,
No.
my lord. He is on bail, my lord. He is not charged.
My lord, I am on bail, but I am insisting for
Okay,
proceeding. Proceeding is going on, my lord.
Serve the notice.
No, stay the proceeding, my lord,
No,
kindly.
It's okay. You're
Because-
on bail. This is not a
Bail,
very,
bail, bail, my lord.
Washing of affair, my lord.
it can be quashed. It can be quashed without a stay.
Let him appear, my lord. They will
Not,
Why I am unnecessarily harassed, my lord?
Service report on respondent number 2 is awaited. List the matter of vacation officer DDI. List the matter after vacation.
Date may be fixed, my lord.
Date at the registry keeps on requesting us not to fix dates.
Okay.
Okay. List the matter immediately after the vacation.
Item 31.
There is some delay in filing the criminal revision petition, Miller, so notice may go, Miller.
You'll have to issue notice. Learned Counsel, Ms. S. Roy is present for the applicants. Full stop. Steps can be taken to issue notice to the respondents. Returnable within 4 weeks. List accordingly.
Much obliged.
Item 32. Wait, please, your lordship. Lordship, this is a limitation petition 170 days for delay, condonation of delay, lordship, filing of this criminal
Have to
appeal,
issue
lordship.
notice 170 days.
Lordship, 170 days, was the state is the party, lordship, because para 5 in my petition, lordship, I have stated, lordship, this petitioner is convicted under 326 and 307 of the IPC, 5 years.
They have one thumb rule. Only 100 days they have no objection. Otherwise they place the objection.
Otherwise, lordship, para 5, lordship. Otherwise, lordship, para 5, lordship, I have stated because.
We'll condone the delay, don't worry. They have a thumb rule, let them follow the rule.
Well, the otherwise, lordship, is state.
Before, if you come on 74 days, they don't say anything. 98
Otherwise-
days also, they won't say anything.
74 days, lordship. Problem is that the poor lady, lordship, after his husband was taken into custody, lordship, till trial, he was in 108 days in trial. After conviction, lordship, he is 9 months already in jail, lordship.
We will hear you.
Now, lordship, the
hear
problem is he is not in a position to hurry and file this case because that is the situation, lordship. Other
Which section?
326 and 307, lordship, 5 years and 10 years. Let them file it.
What was the offense? What did he do?
Lordship, what happened? Nobody has seen, lordship, assaulted the lady, lordship, who is witch practicing, lordship.
Oh, no.
She was
We
it
issue
was-
notice, issue.
But nobody seen, lordship, the assaulting arms was not recovered, lordship.
Full stop steps may be taken to issue notice to the respondent number 2. Full stop learned additional PP is present for the respondent state. List the matter on after 4 weeks.
No, sir, otherwise, lordship, that allegation is not there. He
will
said that
condone the delay.
present petitioner assault him, lordship. That
We
much.
will condone the delay. Don't worry.
Hello.
Make the delay condone.
This delay, also, it is
Huh?
56 days delay in preparing the appeal.
30 days.
Yeah, 26 days.
26 days, he will not place any
Jail
objection.
appeal from
We'll allow. Where is your ground?
paragraph 3,
Learned Counsel, Mr.
B. Haldal, lordship.
B. Haldar is present.
Legal
for the
counsel for the petition.
Balubhadra Bodole, who has filed this application under section 5 of the Limitation Act 1963 with prayer for condoning the delay of 26 days in filing the appeal preferred against the judgment and order dated 21/8/2025 passed by the learned additional session judge special judge POSCO Morigao in POSCO case number 13/2019 convicting the appellant under section 6 of the POSCO Act and sentencing him to rigorous imprisonment for 10 years and to pay a fine of rupees 20,000 with default stipulation, full stop. Learned additional PP, Mr. B. Sharma is present on behalf of the state and has submitted that is present on behalf of the state respondent, full stop. It is submitted on behalf of the petitioner that
Paragraph 5 হচ্ছে
the delay was due to the
official communication.
Huh?
Since it is a case of Lordship, it has come from the district legal service
Okay.
authority Lordship.
Due to the delay in communication relating to the judgment and impugned judgment and order. Full stop. This case has come from the DLSA Morigaon, and the delay was
26th
owing to the
হয়তো পিছত correction করা হবে।
formalities to be observed for obtaining copies and connected papers, full stop. The petitioner is not responsible for the latches and no malafide is discernible on his part. Considering all aspects, delay is hereby condoned, registry to register the connected appeal. Item 34.
With results.
Mm.
There is a delay, 39 days delay.
39
But the
days.
private party, my lord, against under
Oh, private party.
private
we
party,
notice.
my lord.
Lanet
Only
Council
problem, the
Mr.
wife, my lord, she abandoned the husband and her daughter, my lord, lactating daughter, my lord.
Private
My
application.
lord. So that may be given, my lord.
Lanet Council Mr. PJ Soke Ayatul Likiba is present for the applicant. Full stop. Steps will be taken to issue notice to the respondents. One respondent.
Only one, sole
Respondent returnable in returnable.
Short date, my lord.
Short date.
Kindly,
9 January.
my lord. Steps may be, my lord, by Dusty also, my lord,
Yes, no, dusty service is permitted.
my lord, along with the normal. Oblige, lord.
Item 35 for hearing.
Lordship, kindly, matter may be hard after vacation. Can you some person?
2014. After vacation?
Yes.
All right.
In this matter, I was appointed as an amicus matter,
Yes,
but
sir.
I have not received any copy matter.
Okay.
Registry may furnish me the
Okay, amicus for this case?
Yes.
As appellant?
applicant.
Okay. Learned Counsel, Mr.
S. Borua.
S. Burrow is present for the appellant and learned amicus curiae, Mr. S. Das is present. For service to furnish copies of the appeal memo along with relevant copies to the learned amicus curiae. Full stop. The a prayer for adjournment has been made. List this matter for hearing positively without full stop DDA on 20 January. Full stop. On failure or appearance of any of the parties, this appeal will be decided on merits.
Highly